Hello, welcome back. GovDoc Breakdown, no opinions, just facts and summaries of government documents, and we let you take it from there. We got May 29th Supreme Court Order, Highland Capital Management LP v. NexPoint Advisors. All right, this is a bit of an interesting one, but highly technical, so just bear with me. We are stepping into the world of bankruptcy court. So a little background in this case. Highland Capital Management is a Dallas-based investment firm that filed for Chapter 11 bankruptcy. Basically, Chapter 11 means a reorganization bankruptcy used by companies that want to stay in business but need time and legal protection to restructure their finances. And Highland Capital filed for that type of bankruptcy in 2019 due to significant financial liabilities like a $189 million arbitration award to its investors who alleged improper fee payments and delays in fund liquidation. So, the bankruptcy court confirmed a reorganization plan that included provisions designed to shield Highland Capital and associated entities from liability for things that happened during the bankruptcy. There was an exculpation provision, an injunction provision, and a gatekeeper clause. The exculpation and injunction provisions were aimed at releasing certain liabilities for actions taken during the bankruptcy process, while the gatekeeper clause required court approval before initiating litigation or lawsuits against specified parties. The issue, I know that was a lot of information, but the issue in question here is with how the bankruptcy court wrote the provisions and which entities they applied to. The Fifth Circuit Court of Appeals said that the provisions protecting those entities improperly extended to non-debtor parties. So let's define some terms here. In bankruptcy law, non-debtor parties are individuals or entities not themselves filing for bankruptcy, but who are somehow connected to the debtor or the bankruptcy case. So in this case, think like company executives or directors, affiliates or subsidiaries of the company. So basically, the protections that the bankruptcy court wrote in this case extended to those individuals or entities. So the Fifth Circuit is saying that the provisions written in the reorganization plan extended to those entities are not the actual company filing for bankruptcy. That decision was appealed to the Supreme Court, where Justice Alito granted a stay of the Fifth Court's mandate to the bankruptcy court to correct the extension of protections to those non-debtors. So basically, we're putting a pause. The bankruptcy court does not have to go back and correct them as of right now. This means that the Fifth Circuit's order is temporarily halted until further review of the case. If the Supreme Court decides to review the case, then there will be a decision made by them, and if not, the Circuit Court's order will stand. All right, that's it for this one. Kaimo, keep your mind open, do your own research, form your own opinion. See you next time.